We're joined with Colorado's best attorney, Phil Harding. And I understand you have been getting calls about people being injured on someone else's property, and we're going to talk about how to maximize your recovery. So what are we starting with?
Well, we're going to talk about this. They used to be called slip and fall cases. Now they fall under what's known as the Premise Liability Act. Everyone refers to it as the PLA, right, the acronym. And when you were hurt on the property of another, there are just three different types of people that are there. And one of them, two of them are weird words, but the first one is trespasser. We all know what that is, right? And let's go over the kind of the standard of each one. So if you are a trespasser on someone else's property, you can only recover if that person whose property that you're on created that. In other words, if they dug a hole and you fell in that hole. The next one is a licensee, and so let's think about that. So if you're renting an apartment and you're inside your apartment itself, then you can recover from the landlord so long as the landlord had actual knowledge of the defect, right? Like loose boards or the stairs were broken or something like that. The last one is an invitee. Again, really weird words, but let's say, again, apartment complex, but you are in the common area. You're in the hallways or you're going down the stairs. So at that, the landlord can be liable for a dangerous condition that they either knew about or should have known about. So there is one last thing that I want to talk about, because if you're hurt on the sidewalk, maybe the government's involved. And if the government's involved, you have to send them a GIA notice.
So what notice is that?
GIA, all right, so the GIA stands for the Governmental Immunity Act, and let's talk about that. This is one of those archaic laws that we actually brought over from England, and because you're going to be suing the government, back in England there was a saying, and the saying was, the king can do no wrong, right? The king could come in, take property, kill people, do whatever they want. You could never sue the king. So here in the United States, when we started writing our laws, we didn't have a king, but the government became our king. So we said, if the government ever injures you or contributes to it, for example, if there's a sidewalk that wasn't repaired, you have to send the special notice. It's called the GIA, stands for the Governmental Immunity Act notice, within 182 days. And normally there's a 2-year statute of limitations, but you have to adhere to that 182 days.
Because it's the government.
Because it's our king, right?
Our king. All right, when you're injured, who pays for the medical bills?
Yeah,
Good question.
well, this is the biggest misconception. Let's say you're hurt on the property of someone else. The insurance company calls you up and wants a statement. You think that they're going to pay your medical bills. They don't. The other side's insurance company writes one check and only one check at the very end. So watch out for that. If they call you up and they say, hey, can we get a statement? Also remember, there's a law out there that says it's illegal for the other side to get a statement within 15 days if you're injured. So watch out for that. Use your own health insurance. And also, don't send your medical bills to the other side. And I want to tell you why. We've looked at this before, and you know, if you have health insurance, Medicaid, or Medicare, you get billings back from the health insurance, and they're called EOBs, which stands for an explanation of benefits. And we've got one here, right? And this is a real EOB. And normally, this is like from Swedish. This is a client, went to Swedish Medical Center, and this was for surgery. Swedish itself billed $29,000, but your health insurance came back and said, no, we get a discount. We get $20,000, and the amount that's covered by the plan is $8,500. Here's where it's really important. The other side wants to see this bill so that when they settle, they go, all right, we're going to pay you $8,500 because you got this discount. Don't show it to them. The only reason that you got that discount is either because you have Medicaid, Medicare, or you've been paying for health insurance premiums. Come back to me. I want to show you something. So you see this? There's the bill. Now, this is the way you should send it out, where it's redacted. The only thing that you show them is the $29,000. If you don't do that, you're not going to get $29,000 from the other side, and that's just for one medical bill. You get pain and suffering and all that other stuff, and that's only one medical bill. So please, to the other side, they're not your friend, they're not your buddy. You're not going to hang out over the weekend and have a barbecue, right? They have two jobs: protecting the person that hurt you and making money for their company. So watch out for that. Don't send them those medical bills.
All right, thank you. You always have Great advice. I've learned so much from you, and I've actually used it. It's good stuff.
I know you have.
I have.
Good.
So if you have a question for our legal expert, go to kdvr.com and click on Colorado's Best. You're going to see Phil Harding's photo on the right. Just click there and send in your questions. He will answer each question personally and confidentially. And to reach Harding and Associates directly, call 303-762-9500. And you can get a free consultation anytime. You can also find him online at hlaw.com.